They ran a campground on land they didn't own. They charged people to sleep on my canyon property without asking, without permits, and without any warning system in place. When the county issued a flash flood alert, I had documented everything. I had the survey maps, the trespass notices, the ignored letters, and the liability filings. When water came down that canyon at 3 in the morning, every camper evacuated safely, because I had already called the county myself. The people who built that operation never saw a single dollar of judgment money. I bought that canyon land 11 years ago. It was not a fashionable purchase. The real estate agent called it recreational acreage, which is a polite way of saying it was steep, dry, and difficult to build on. The price reflected that. I paid cash, and I recorded the deed the same week. The parcel runs along the eastern wall of a narrow canyon in a rural county. There is one dirt road in, there is one dirt road out. The canyon bottom floods seasonally. I knew that when I bought it. The county surveyor's maps showed the floodplain boundary clearly. I had those maps in a binder before I ever set foot on the property. I did not buy it to develop. I bought it because I wanted land that was mine. I had grown up renting. I had spent 20 years in apartments and shared walls and landlords who could end your life with 30 days' notice. Owning something outright, something with legal boundaries and a recorded deed, meant something to me that is hard to explain to people who have always owned property. I visited the land 4 or 5 times a year. I cleared brush near the road. I maintained a small trail along the eastern rim. I paid my property taxes on time every year. I never had a neighbor problem because I barely had neighbors. The nearest occupied structure was a ranch house about a half-mile north, owned by a family I will call the Drells. I knew the Drells by sight. We waved when we passed on the county road. That was the entirety of our relationship for the first 8 years. Then the Drells sold their ranch. The ranch sold in late spring. I found out the way you find out about things in rural counties. Someone mentioned it at the feed store. The new owners were a couple. I will call them Brent and Cassandra Howell. They had moved from a mid-sized city about 4 hours away. They paid more for that ranch than it was worth by most local measures. People talked about that too. I did not think much about it at first. New owners come in. They fix fences. They learn which roads wash out in March. Most of them settle down after a season or two and become ordinary neighbors. I had no reason to expect anything different from the Howells. That first summer was quiet. I visited my land twice. I walked the Eastern Rim Trail. I checked the culvert at the road entry. Everything was as I had left it. The canyon was dry. The brush was manageable. I took photographs the way I always did, dated and stored on an external drive at home. That was a habit I had developed years earlier for insurance purposes. It had nothing to do with the Howells. It was just what I did. I noticed one thing on my second visit that summer. There was fresh tire track impressions on the dirt road that leads to my lower parcel. The road is on my property from the cattle guard forward. I had posted it years ago with a simple sign. Private road, no trespassing. The sign was still there. The tracks were there too. I took a photograph of the tracks. I noted the date in my log. I did not call anyone. I did not drive to the Howell Ranch. It was possible a hunter had turned around there. It was possible it was nothing. I told myself it was probably nothing. I was wrong about that. The following spring, I drove out to the property on a Saturday morning in April. It was an ordinary visit. I brought my camera, my log notebook, and a pair of work gloves. I planned to clear some deadfall near the trailhead and check the culvert after winter runoff. I turned off the county road onto my dirt road and stopped at the cattle guard. Something was different. The ground on both sides of the entry had been graded. Someone had smoothed the soil and filled in the ruts that had been there for years. Fresh gravel had been spread on the road surface for at least 30 feet past the cattle guard. I sat in my truck for a moment. I did not get out immediately. I looked at the gravel. I looked at the grade work. I took a photograph through the windshield. Then I got out and walked forward slowly. The gravel continued further than I could see from the road. It went around the first bend. I followed it on foot. Past the bend, the road opened into the wide, flat area near the canyon rim that I used as a turnaround. That flat area had been cleared. Not brushed back the way I did it. Cleared. The scrub oak and manzanita that had grown along the northern edge for as long as I had owned the property were gone. The ground had been leveled with equipment. I could see the blade marks in the soil. There were 4 wooden posts set in the ground in a rough rectangle. They were new. The wood was still pale. No signage on them yet. But they were set with intention. Someone had used a post driver or a tractor attachment. These were not casual stakes. They were anchored. I stood there for a long time. Then I walked the full perimeter of my lower parcel. It took about 40 minutes. What I found over the course of that walk told me exactly what was being planned. Along the canyon rim, there were 3 more cleared areas, smaller than the first. Each one was roughly level. Each one was positioned with a view down into the canyon. In 2 of the cleared areas, there were fire ring stones arranged in circles. River rock, carried up from somewhere, arranged carefully. The kind of arrangement you make when you want a campsite to look intentional and inviting. At the southern end of the parcel, I found something that removed any remaining doubt. There was a hand-painted sign leaning against a juniper tree. It had not been posted yet. It read, "Canyon View Camp, Sites 1 through 6. Check in at Main Ranch." I read that sign twice. Then I photographed it from 3 angles. I photographed the fire rings. I photographed the cleared areas. I photographed the post holes and the gravel road. I spent 2 hours on that property documenting everything I could see. I filled 16 pages in my log notebook with descriptions, measurements, and sketches. When I got home, I pulled out my deed. I laid it on the kitchen table next to my county survey maps. I traced the boundary lines with my finger. Every cleared area, every fire ring, every post hole, all of it was inside my recorded boundary. Not near the boundary, not ambiguous, inside it by a significant margin in most places. I am not a lawyer, but I have owned land long enough to understand a few basic things. Someone had entered my property without permission. Someone had used equipment on my property without permission. Someone had made physical improvements to my property without permission. And someone was planning to charge members of the public to occupy my property without permission. I did not call the Howells that night. I thought about it. I decided against it. I had learned something over the years about situations like this. Not this exact situation, but situations where someone has already invested time and money and planning into something. When someone has already done all of that, a phone call does not make them stop. It makes them defensive. It makes them look for arguments. It gives them time to construct a position before you have constructed yours. I needed to build my position first. The next morning, I called the county assessor's office and requested a certified copy of my deed and the current parcel map. I called a land survey company I had used before and scheduled a boundary survey for the following week. I called my insurance agent and reported a potential unauthorized use situation on my property. I wrote down every call I made, the time, the name of the person I spoke with, and a summary of what was said. Then I drove to the county building department. I asked a clerk whether any grading permits or land use applications had been filed for my parcel number. She checked. Nothing had been filed. I asked whether any campground or recreational use permits had been applied for under the Howell name or the ranch parcel adjacent to mine. She checked that too. Nothing. No permits. No applications. No variance requests. Nothing. I asked her to print me a confirmation of that search. She looked at me a little sideways, but she printed it. I dated it, signed it as a true record, and put it in a new folder I labeled with the date and the word documentation. That folder would eventually hold over 300 pages. The boundary survey was completed on a Thursday. The surveyor was a methodical man who had worked that county for 30 years. He did not rush. He checked his equipment twice before he started. He walked every line. He set new corner markers where the old ones had degraded. When he handed me his report at the end of the day, he pointed to the northeastern corner marker and told me that someone had recently disturbed the soil within 6 inches of it. I asked him what that meant in practical terms. He said it meant someone had been working near the boundary and either did not know where it was or did not care. I asked him which he thought it was. He looked at the gravel road and the cleared areas for a moment. Then he said he thought it was the second one. I paid him, and I asked him to notarize his field report. He did. I added it to the folder. That weekend, I drove past the Howell Ranch on the county road. I did not stop. I drove slowly. I looked at the entrance. There was a new sign on their gate. It was professional, printed on weather-resistant board. It said, Canyon View Camp. Open May through October. Reservations at canyonviewcamp.com. They had a website. They had a season. They had a reservation system. I drove home. I opened my laptop and I went to that website. It loaded cleanly. There were photographs. The photographs showed the cleared areas on my land, the fire rings on my land, the canyon rim view from my land. The site listed 6 campsites. Prices ranged from $45 to $75 per night, depending on the site. There was a 5-night minimum on holiday weekends. There were already 14 reviews on a linked outdoor recreation platform. The reviews averaged 4.8 stars. People described it as a hidden gem, a peaceful escape. One reviewer wrote that the canyon views at sunrise were unlike anything they had seen. Those views were from my property. I took screenshots of every page. I documented the URL. I noted the date and time. I printed the pages and added them to the folder. Then I did something I had been holding off on. I wrote a letter. It was not an angry letter. I had written angry letters before in my life, and they had never helped anything. This letter was 4 paragraphs. The first paragraph identified me as the recorded owner of the parcel. The second paragraph described the unauthorized improvements and the planned commercial use. The third paragraph stated clearly that no permission had been granted and that all activity must cease immediately. The fourth paragraph said I expected a written response within 10 business days. I sent it certified mail with return receipt. I kept a copy. The return receipt came back signed 8 days later. Cassandra Howell had signed for it. I noted the date in my log. I waited the full 10 business days. No response arrived. On the 11th day, I drove out to my property. I needed to see whether anything had changed. What I found was that things had not changed. They had expanded. The gravel road had been extended further along the canyon rim. A new cleared area had been added at the far southern end of my parcel. That brought the total to 7 distinct campsites, not 6. There was now a small wooden structure near the original turnaround area. It was roughly the size of a garden shed. It had a metal roof. It was sitting on 4 concrete deck blocks. A pipe extended from the back of it and ran toward the canyon edge. I did not know what the pipe was for at that moment. I found out later it was a gray water drain that discharged directly into the canyon. I photographed everything. I measured the new structure as best I could with a tape measure. I noted its position relative to the surveyor's corner markers. It was entirely on my land. I sat on a rock near the rim for a while after that. I looked down into the canyon. The creek bed was dry that time of year. In wet years, it ran hard. The canyon walls narrowed about a quarter mile south of my parcel, and the water moved fast through that section when it came. I had seen it once after a heavy rain. It was not something you wanted to be near. I thought about the campers. 14 reviews already. More bookings coming for the summer. People who had no idea whose land they were sleeping on. People who had no idea what that canyon could do in a storm. That thought stayed with me. I drove home, and I made 2 calls. The first was to a real estate attorney in the county seat. I had found her name through a referral from the surveyor. I explained the situation briefly. She asked me to bring my documentation to an appointment the following week. The second call was to the county planning department. I asked whether a campground operating commercially on unzoned rural land required a conditional use permit. The answer was yes. I asked whether any such permit had been issued for my parcel or the adjacent ranch parcel. The answer was no. I asked the planning department clerk to send me that confirmation in writing. She said she could send an email. I gave her my address and I received that email within the hour. I printed it. I added it to the folder. The folder was getting thick. I bought a second one. The attorney's name was Margaret Ellison. She had practiced real estate and property law in that county for 19 years. Her office was small and her desk was covered in files, but she knew exactly where everything was. I laid my documentation on the table in front of her in the order I had collected it. She went through it without saying much. She asked 2 questions. The first was whether I had ever given the Howells verbal permission for anything. I said no. The second was whether I had any prior relationship with them beyond waving on the county road. I said no. She sat back and looked at the survey report for a moment. Then she said I had a straightforward trespass case, a strong conversion claim for the improvements made to my land, and potentially a nuisance claim, depending on how the gray water discharge situation developed. She said the commercial operation added a layer that would interest the county as well as the court. She said the lack of permits was significant. She also said something that I had already been thinking about. She said that if people were being charged money to camp on land without proper permits, without proper flood disclosure, and without the landowner's consent, there was a liability exposure that went well beyond property law. I asked her what she meant specifically. She said that if a paying guest was injured on my land that was being operated as a commercial campground without my knowledge or permission, the question of who bore responsibility would be complicated and contested. She said courts had found landowners liable in some circumstances, even when they had not authorized the use. She said the better path was to move quickly and create a clear legal record that I had objected, that I had notified the operators, and that I had taken affirmative steps to stop the activity. I told her I had already done all of that. She smiled for the first time since I had walked in. She said that was good. She said to keep doing it. She drafted a formal cease and desist letter on her letterhead. It was more precise than mine had been. It cited specific statutes. It named the trespass, the unauthorized improvements, the commercial operation, and the unpermitted discharge. It gave the Howells 5 business days to respond and to provide a written commitment to cease all operations and restore the property to its prior condition. It went out certified mail the same week. I kept a copy. Margaret kept a copy. While we waited for the response period, I kept documenting. I drove past the property every few days. I did not go onto my land during that period. Margaret had advised me to avoid any direct contact that could be characterized as confrontational. I photographed from the county road where I could. On one visit, I counted 11 vehicles parked along the road near the entry to my property. It was a Friday evening in late May. The campground was operating at what appeared to be full capacity. I noted the vehicle count. I noted the date and time. I photographed the vehicles without capturing license plates. I was not trying to identify anyone. I was documenting volume and frequency of use. On the third day of the response window, I received a phone call from a number I did not recognize. It was Brent Howell. I do not know how he got my number. I did not ask. He was not hostile on the call. Not at first. He said he wanted to talk neighbor to neighbor. He said there had been some miscommunication. He said he thought the boundary line ran differently than my surveyor had marked it, and that he had his own survey that showed the campsites were on his land. I listened to everything he said. I did not argue. I did not raise my voice. When he finished, I told him that any communication going forward should be directed to my attorney. I gave him Margaret's name and number. Then I ended the call. I wrote down everything he had said within 5 minutes of hanging up. Date, time, duration, full summary. I added it to the folder and emailed a copy to Margaret. The 5-day response window closed without a written reply from the Howells. Brent's phone call was the only contact. Margaret noted that in her file. She sent a follow-up letter informing them that their failure to respond had been recorded and that we were proceeding accordingly. 2 days after that second letter was delivered, I drove out to the property and found something new. Someone had removed my no trespassing sign from the entry post at the cattle guard. The post was still there. The sign was gone. In its place, someone had zip-tied a small laminated card that read, "Canyon View Camp. Guests welcome. Follow road to sites." I photographed the post. I photographed the laminated card. I photographed the zip ties. I removed the card carefully, bagged it, and brought it home. I put a new no trespassing sign on the post before I left. I used a steel mounting bracket this time and tamper-resistant screws. I called Margaret that afternoon. She said the removal of a posted no trespassing sign was a separate offense under state code. She said to add it to the documentation. I did. That same week I contacted the county sheriff's office. I filed a formal trespass complaint. The deputy who took my complaint was professional and thorough. He asked for the deed, the survey, and the cease and desist letters. I had all of it with me. He made copies of everything. He said a deputy would make contact with the Howells and document the complaint. He said it was unlikely to result in immediate arrest, but that it created an official record. I said that was exactly what I wanted. The deputy contact happened 3 days later. Margaret heard about it through the county attorney's office, which had been copied on our permit inquiry. Apparently, when the deputy arrived at the Howell Ranch, Brent told him the land was his and showed him a hand-drawn map. The deputy noted the hand-drawn map in his report and advised Brent that a certified survey and recorded deed would be required to contest the boundary, and that in the meantime, the posted land designation stood. Brent reportedly told the deputy that the whole thing was a misunderstanding and that he planned to get it sorted out. The campground did not close. That weekend I drove past again. 14 vehicles. A small canopy tent had been set up near the road entry with a folding table under it. A young woman was sitting at the table. She appeared to be a check-in attendant. There was a small chalkboard sign propped against the table leg showing site availability. They had hired staff. I photographed all of it from the county road. I noted the date and the time and the vehicle count. Then I drove to the county planning office and hand-delivered a formal complaint about an unpermitted commercial campground operating on my parcel. I asked for a case number. They gave me one. The planning department assigned an inspector to my complaint within a week. His name was Gerald Foss. He was a quiet man, close to retirement age. who had inspected land use violations in that county for most of his career. He called me before his site visit and asked me to walk him through the documentation. I spent 40 minutes on the phone with him, going through the folder item by item. He visited the property on a Tuesday morning. I was not present. Margaret had advised me to let the county do its work without my involvement at that stage. Gerald Foss walked the parcel, verified the survey markers, and inspected each campsite. He also found things I had not documented yet. He found that the small shed structure had been connected to an improvised water line running from the ranch property. The line crossed the boundary underground. It was not permitted. He found that a section of the canyon rim had been graded to create a footpath down into the canyon bottom. That grading had destabilized a section of the rim wall. He noted it as an erosion hazard. He also documented the gray water pipe I had photographed earlier. He confirmed it discharged into the canyon without any treatment or containment system. His inspection report was thorough. It cited 7 distinct violations of county land use code. It listed unauthorized grading, unpermitted commercial operation, unpermitted water line installation, improper waste discharge, and operation of a public accommodation without a health and safety inspection. Each violation carried a separate fine. The fines were not enormous individually. Together they added up to just over $9,000. More importantly, the report required the Howells to cease commercial operations immediately pending resolution of all violations. The cease order was posted on the property and mailed to the Howells the same day the report was filed. I received a copy because I was the recorded landowner of the parcel in question. I read it carefully. I added it to the folder. The folder was now 2 full binders. That evening, I allowed myself a quiet moment, not celebration. It was too early for that, but I recognized that the situation had shifted. For 2 months, the Howells had operated as though my documentation and my letters and my complaints were minor inconveniences, as though I would eventually give up or accept some small payment and look the other way. The county cease order was something different. It had teeth. It had a case number. It had deadlines. It also had something else I had not anticipated. Gerald Foss had noted in his report that the campground's location within the canyon floodplain, combined with the unpermitted rim grading and the absence of any emergency egress plan, represented a potential public safety concern. He had flagged that section of the report for review by the County Emergency Management Office. That flag would matter more than any of the fines. The Howells did not close the campground after the cease order. I found this out on the following Saturday when I drove past and counted 9 vehicles parked along the road. The check-in table was gone. The chalkboard sign was gone. But the vehicles were there, and the gravel road into my property showed fresh tire tracks. They had simply removed the visible commercial trappings and continued operating quietly. I called Margaret on Monday morning. She had already heard. The county planning office had received a response letter from a man I will call Dale Pritchard. He was an attorney the Howells had retained. His letter was aggressive in tone. It argued that the county inspection had been conducted without proper notice, that the boundary dispute between the parties rendered the cease order premature, and that his clients were prepared to challenge the violations on procedural grounds. He requested a 30-day extension before any fines were assessed. Margaret read me the key sections over the phone. She was calm about it. She said it was a standard delay tactic. She said the boundary dispute claim was the part worth watching because it was the only argument with any potential traction. She said Brent had apparently followed through on his mention of an alternate survey. I asked her how concerned I should be. She said not very. She said a hand-drawn map and a privately commissioned survey that contradicted a recorded deed and a certified boundary survey would face a high burden in court. She said the Howells would need to show a chain of title argument or a historical boundary discrepancy to have any real chance. She said she had already pulled the title history on both parcels and found nothing that supported their position, but she also said the delay tactic would work in the short term. The county would likely grant the extension. The campground would keep operating through at least part of the summer. That is exactly what happened. The county granted a 25-day extension. Dale Pritchard filed 2 additional procedural motions during that window, each one buying more time. The campground operated through June and into July. The website stayed up. The reviews kept coming. By mid-July, the outdoor recreation platform showed 41 reviews and a 4.9-star average. I kept documenting. Every weekend I drove past. I counted vehicles. I photographed the entry. I noted dates and times. I was building a record of continuous operation in defiance of a county cease order. Every day they stayed open after that order was another line in my log. Margaret filed our civil trespass suit in county court at the end of June. The filing named both Brent and Cassandra Howell. It cited trespass, conversion, nuisance, and unjust enrichment. The unjust enrichment claim was based on the revenue they had collected from operating a commercial campground on my land. Margaret had calculated a conservative estimate based on the published site rates, the review volume, and the operating dates. The figure she used in the filing was $38,000. Dale Pritchard responded to our civil filing within 2 weeks. His answer denied all material claims. It included a counterclaim alleging that my no trespassing signs and my complaint to the sheriff had interfered with the Howells' lawful business operations and caused them reputational harm. He put a figure on that counterclaim. It was $50,000. I read that number, and I felt something that was not quite anger. It was closer to clarity. They were not trying to settle. They were trying to intimidate. The counterclaim was designed to make me calculate the risk of continuing and decide it was not worth it. I called Margaret. She said she had seen this approach before. She said the counterclaim had no legal foundation because I had every right to post my own land and file complaints about unauthorized use. She said it would be dismissed. She said the more important thing was that they had now committed to a legal fight, which meant discovery, which meant they would have to produce their records. Their records were what I wanted. The booking history, the revenue figures, the communications about the property, any internal discussion about the boundary, any acknowledgement that they knew where my land ended and theirs began. Discovery would take time. We were now in a formal litigation process with deadlines and filings and a judge assigned to the case. The judge was a woman named the Honorable Patricia Crane. Margaret said she had a reputation for efficiency and low tolerance for procedural gamesmanship. That reputation proved accurate. When Dale Pritchard filed a motion to stay discovery pending resolution of the boundary dispute claim, Judge Crane denied it within 4 days. Her written denial was 2 paragraphs. The second paragraph noted that a boundary dispute claim, unsupported by any recorded instrument or title defect, did not constitute grounds to delay discovery in a trespass matter. I read that denial 3 times. Meanwhile, the county process was continuing on its own track. The planning department had not forgotten about the cease order. After Pritchard's extension ran out, the county issued a formal notice of violation with a compliance deadline. The Howells missed that deadline. The county assessed the fines. Pritchard appealed the fines to the County Board of Appeals. The Board of Appeals hearing was scheduled for late August. But something happened in late July that changed the shape of everything. The County Emergency Management Office completed its review of Gerald Foss's flagged report. They sent an inspector of their own to assess the flood risk at the campground site. That inspector walked the canyon rim. He measured the gradient of the creek bed. He reviewed 10 years of precipitation and flood event data for that watershed. He looked at the unpermitted rim grading and the destabilized wall section. He filed his report on a Thursday afternoon. By Friday morning, the county had issued a formal public safety advisory for the canyon parcel. The advisory cited imminent flood risk during storm events and required that no overnight occupation occur within the floodplain boundary without an approved emergency action plan. The Howells had no emergency action plan. The public safety advisory was not an order to close. It was a notice. It stated the risk. It stated the requirement for an emergency action plan. It gave the operator 30 days to submit one for county review. The Howells did not submit one. I know this because Margaret requested the county file under a public records request, and the file showed no submission. The 30-day window closed in late August. The county sent a follow-up notice. Pritchard responded on the Howells' behalf with a letter arguing that the advisory did not apply because the land use question was under active litigation and therefore the county's jurisdiction was in dispute. The county disagreed. They sent a second notice with a shorter deadline and a statement that failure to comply would result in referral to the county council for enforcement action. Pritchard sent another letter. The letters were becoming a pattern. Every deadline produced a letter. Every letter produced a delay. It was the same tactic that had worked in the planning department process. Run out the clock. Keep the campground open through the season. Hope the other side gets tired. I was not tired. I had been watching the weather. That canyon sits at the base of a watershed that drains a significant area of high ground to the north and east. I had studied that watershed when I bought the land. I understood what it meant when a storm system stalled over the high country. I had seen the creek bed go from dry to running in under 2 hours after a heavy rain event. The narrow section a quarter-mile south of my parcel acted as a natural choke point. Water backed up behind it and then moved through fast and hard. The National Weather Service had been tracking a late-season storm system building offshore. The forecast models were showing potential for significant precipitation over the watershed area within a 10 to 14-day window. I watched those forecasts every morning. I noted the probability percentages in my log. I was not hoping for a flood. I was not trying to engineer anything. I was simply paying attention to something that was always there and that the Howells had never bothered to learn about. In the second week of September, I called the County Emergency Management Office directly. I spoke with a coordinator named Paul Whitfield. I identified myself as the recorded landowner of the Canyon parcel. I told him I was aware of the outstanding compliance issue with the Public Safety Advisory. I told him I was monitoring the weather forecast and that I had personal knowledge of how that watershed behaved in significant rain events. I told him I believed there were people camping on that parcel most weekends and that those people had no awareness of the flood risk. Paul Whitfield listened carefully. He asked me several questions about the watershed and the creek behavior. I answered based on my own observation over 11 years. He asked whether I had documentation of the ongoing camping activity. I told him I had dated photographs going back to spring showing continuous use. He said he would look into it. Paul Whitfield called me back 2 days later. He had reviewed the file. He had spoken with Gerald Foss. He had looked at the weather forecast. He told me the county was escalating the advisory to a formal closure order for the parcel pending submission and approval of a compliant emergency action plan. The order would be posted on the property and served on the Howells by certified mail. He also told me something else. He said the Emergency Management Office was coordinating with the county sheriff to ensure the closure order was enforced. If people were found camping on the parcel after the posting date, the sheriff's office would have authority to remove them and cite the operator. I thanked him. I wrote down everything he said. I added it to the folder. The closure order was posted on a Monday. I drove past that afternoon. The orange notice was visible from the county road, attached to the entry post at the cattle guard. It was large and clearly printed. It cited the flood risk. It cited the missing emergency action plan. It cited the county code section under which the closure was ordered. It stated that overnight occupation of the parcel was prohibited until further notice. That Friday evening, I drove past again. There were 6 vehicles parked along the road. I called the sheriff's non-emergency line. I identified myself as the landowner. I reported that the parcel subject to the county closure order appeared to have occupants. I gave the deputy my case number from the original trespass complaint. He said a unit would respond. I drove home. I did not wait at the property. That was not my role at that point. The following morning, I received a call from the sheriff's office. The deputy who had responded the previous evening told me that 2 campsites had been occupied when he arrived. He had informed the occupants of the closure order. The occupants had been cooperative. They had not known about the closure. They had booked through the website and arrived to find what appeared to be a normal operating campground. They packed up and left without incident. The deputy had also attempted to contact the Howells at the ranch. Cassandra Howell had answered the door. She had told the deputy the closure order was under appeal and that the campground was legally operating pending that appeal. The deputy had informed her that a posted closure order was enforceable regardless of appeal status, and that if the campground continued to operate, she and her husband could face criminal charges for violating a public safety order. Cassandra Howell had closed the door without responding. I noted all of this in my log. I emailed a summary to Margaret. She said the criminal exposure for violating a public safety order was a significant development. She said it changed the calculus for the Howells considerably. She said she expected Pritchard to make contact soon. She was right about that. Pritchard called Margaret 3 days after the sheriff's visit. He was measured on the call, but Margaret said the tone had changed. The counterclaim posturing was gone. He asked whether there was any interest in a pretrial settlement discussion. Margaret told him she would consult with her client and respond within a week. She called me that afternoon. She walked me through what a settlement might look like from their side. They would want the civil suit dropped. They would want the county violations resolved quietly. They would likely offer some payment to make it go away. She asked me what my priorities were. I told her my priorities had not changed. I wanted the land restored. I wanted the commercial operation permanently ended. I wanted the improvements they had made either removed or signed over to me at no cost. and I wanted acknowledgement in writing that the land was mine and that they had operated on it without authorization. Margaret said that was a strong position. She said the flood risk situation and the criminal exposure made it stronger. She said to let her handle the response. While the settlement discussion was in its early stages, something happened that I had not planned for and could not have controlled. One of the campers who had been turned away by the sheriff wrote about the experience. He posted it on an outdoor recreation forum. It was a long post. He described booking the campground, driving several hours to reach it, arriving to find other campers already there, and then being told by a sheriff's deputy that the land was under a closure order and that the whole operation was apparently running on someone else's property without permission. He was not angry in the post. He was matter of fact. He said he wanted other people to know before they booked. The post was picked up by a regional hiking and camping community page. Then it was shared more broadly. Within a week, it had been seen by a significant number of people in the outdoor recreation community in that region. The Canyon View Camp listing on the outdoor recreation platform began receiving one-star reviews, not from people who had bad camping experiences, from people who had read the forum post and were warning others. Several reviews mentioned the land dispute specifically. One review mentioned the flood risk. The 4.9-star average began to fall. I did not write any of those reviews. I did not share the forum post. I did not contact anyone in the outdoor recreation community. I simply watched it happen. The Howells had built their reputation on that platform, and that reputation was now doing what reputations do when the foundation underneath them is not solid. Pritchard sent Margaret a letter asking her to send cease and desist communications to the forum posters. Margaret reviewed it and told me I had no obligation to do anything of the sort. She said the forum posts were protected expression based on accurate factual information. She filed the letter and moved on. The settlement discussions stalled in late September. Pritchard had made an initial offer that was below what Margaret considered serious. He offered $12,000, removal of the shed structure, and a mutual release of all claims. The mutual release would have required me to drop the civil suit and sign away any future claims related to the matter. Margaret declined on my behalf without a counter. She said the offer told us something useful. It told us they were not yet feeling enough pressure to settle reasonably. She said the public exposure and the criminal risk had not fully registered with them yet. She said to wait. The weather made waiting easier. The storm system that the National Weather Service had been tracking came ashore in the second week of October. It stalled over the high country north and east of the canyon for nearly 18 hours. The precipitation totals in the watershed were significant. The creek bed in the canyon bottom went from dry to running hard within 90 minutes of the rain beginning. I was at home watching the weather radar when my phone rang. It was Paul Whitfield from County Emergency Management. He told me the canyon watershed was under an active flash flood warning. He told me his office had confirmed with the sheriff that no occupants were currently on the parcel due to the closure order enforcement. He said he wanted me to know because I was the landowner of record and because my earlier call had been part of what prompted the enforcement action. I thanked him. I sat with that for a moment. Nobody was in that canyon that night because a closure order had been enforced. That closure order had been triggered by a public safety advisory. That advisory had been flagged by an inspector responding to a complaint. That complaint had included documentation I had been building since April. Every photograph, every log entry, every certified letter, every permit inquiry, all of it had led to this specific outcome on this specific night. The creek crested and moved through the narrow section fast and hard. It took out a section of the improvised footpath the Howells had graded into the rim wall. It deposited debris across the lower portion of the gravel road they had laid on my property. In the morning, the canyon bottom was scoured clean for a quarter mile. I drove out the next day. I walked the perimeter carefully. I photographed the damage to the graded rim section. I photographed the debris on the road. I photographed the creek bed scour. I noted everything in my log. Then I called Margaret. I told her what had happened. She was quiet for a moment. Then she said the flood event changed the settlement calculus entirely. She said any reasonable attorney looking at that situation would now understand what liability exposure their clients had been carrying all summer. She said to expect a different conversation from Pritchard very soon. Pritchard called Margaret 4 days after the flood event. The tone of the call was different from anything that had come before. He did not open with procedural arguments. He did not mention the boundary dispute. He asked directly what it would take to resolve the matter. Margaret told him. She laid out 5 conditions. First, a full written acknowledgement that the land was mine and that the Howells had operated on it without authorization. Second, complete removal of all structures, improvements, and materials they had placed on my property at their expense within 60 days. Third, restoration of the land surface to its pre-disturbance condition, including the graded areas and the rim path, certified by a licensed contractor and inspected by Gerald Foss. Fourth, payment of all county fines without contest. Fifth, payment to me of $42,000, representing the estimated revenue from the campground operation, plus my documented legal and survey costs. Pritchard said he would take it to his clients. He called back in 2 days. He said his clients would agree to conditions 2, 3, and 4. They would not sign a written acknowledgement of unauthorized operation. They would not pay $42,000. He offered $20,000 and a mutual release. Margaret said no to the mutual release. She said the acknowledgement was non-negotiable. She said the figure was $42,000 and that it reflected actual documented losses, not a negotiating position. Pritchard said his clients needed more time to consider. Judge Crane had set a pretrial conference for early November. That deadline was now 3 weeks away. Both sides knew that if we went into that conference without a settlement, the case would proceed to trial. Trial meant full discovery. Full discovery meant the Howells would have to produce every booking record, every revenue figure, every internal communication about the property and the boundary. Margaret had already submitted our discovery requests. Among the items requested were all communications between Brent and Cassandra Howell regarding the canyon parcel from the date they purchased the ranch forward. All financial records related to Canyon View Camp, all communications with any surveyor or land professional regarding the boundary, and all insurance documents related to the ranch property and any commercial operations. The insurance request was the one that mattered most. Margaret had a theory. She believed the Howells had either not disclosed the campground operation to their property insurer or had obtained a commercial rider without disclosing the boundary dispute. Either way, the insurance situation was likely complicated. If their insurer learned through discovery that they had operated a commercial campground on disputed land without permits, adjacent to a flash flood zone, after receiving multiple cease orders, the policy implications would be serious. Pritchard knew that too. The week before the pretrial conference, he called Margaret again. He said his clients were prepared to meet all 5 conditions with one modification. Instead of a written acknowledgement of unauthorized operation, they would sign a stipulated settlement agreement that included a factual recitation of the events without using the word unauthorized. Margaret brought that to me. She said the factual recitation would accomplish the same legal purpose. It would state that they had operated the campground on my parcel without my permission. The word choice was different. The legal effect was the same. I agreed to it. The stipulated settlement agreement was signed 5 days before the pretrial conference. Judge Crane reviewed it and approved it at a brief hearing. The case was closed. The counterclaim was withdrawn with prejudice, meaning it could not be refiled. I sat in that courtroom and watched the judge sign the approval order. It took less than 10 minutes. All of the months of documentation, the certified letters, the survey, the permit complaints, the sheriff calls, the planning department filings, the emergency management coordination, the civil suit, the discovery requests, all of it had led to 10 minutes in a quiet courtroom on a Tuesday morning in November. The Howells did not attend the hearing. Pritchard appeared on their behalf. He did not make eye contact with me. The remediation work began 3 weeks later. The contractor the Howells hired was competent. He removed the shed structure completely, including the concrete deck blocks and the gray water pipe. He pulled the fence posts. He removed the fire ring stones and hauled them away. He graded the cleared areas back toward their natural contour and seeded them with native ground cover mix. He capped the improvised water line at the boundary. Gerald Foss inspected the work twice during the process, and once upon completion, he signed off on the restoration in December. The gravel road took longer. The contractor had to remove several inches of compacted gravel from the full length of the road and restore the original dirt surface. The culvert at the entry was cleaned and reset. The cattle guard was left in place because it had been there before the Howells purchased the ranch and was part of the original property infrastructure. I drove out to the property on the first clear day after the restoration was certified. I parked at the cattle guard and walked the full perimeter the way I always had. It took about 40 minutes. The cleared areas were seeded and already showing the first pale green of ground cover coming in. The fire ring stones were gone. The posts were gone. The shed footprint was smoothed over. The gravel was gone from the road surface, and the dirt beneath showed the familiar ruts and textures I had known for 11 years. I stood at the canyon rim for a while. The creek bed below was dry again. The scour marks from the October flood were still visible on the canyon walls. The section of rim path the water had taken out was raw earth now, beginning to stabilize on its own. The $42,000 payment arrived by wire transfer on the date specified in the settlement agreement. I paid Margaret's fees from that amount. The remainder covered the survey cost, my documentation expenses, and left a balance that I put into a separate account I keep for property maintenance. The Canyon View Camp website went offline the week after the settlement was signed. The listing on the outdoor recreation platform was removed. The reviews disappeared with it. The check-in table and the chalkboard sign were gone from the road entry. There was nothing left of the operation except the seeded ground cover slowly filling in where the campsites had been. I continued to visit the property 4 or 5 times a year the way I always had. I walked the trail, I checked the culvert, I took photographs and logged the dates. Nothing had changed about how I maintained the land. The only difference was that I now had a second set of corner markers, freshly set by the surveyor, and I checked them on every visit. The Howells sold the ranch the following spring. I found out the way I always found out about things in that county. Someone mentioned it at the feed store. The new owners were a quiet couple who ran cattle and kept to themselves. We waved when we passed on the county road. That was enough. I thought about what had made the difference in all of it. It was not the lawsuit. It was not the attorney, though Margaret was essential. It was not the flood, though the flood clarified things quickly for everyone involved. What had made the difference was the folder, the dated photographs, the certified letters, the log entries, the permit inquiries, and the printed confirmations, the survey, the documentation that I had started building before I had any reason to think I would need it. I had not known in April that I would be in a courtroom in November. I had not known that a flood would come in October and make everything concrete. I had not planned any of it as a strategy. I had simply documented what I saw, when I saw it, accurately and completely. I had let the record build itself. That is the only thing I know how to tell someone who finds themselves in a situation like this. Do not shout, do not threaten, do not confront, document, file, follow the process. The law moves slowly, but it moves in one direction when the record is clear. My land is still mine. It is quiet again. The ground cover is coming in thick on the old campsites now. In another season, you will not be able to tell anything was ever there. I walk the rim trail when I visit, and I look down into the canyon the way I always have. It is my land. I paid for it. I have the deed. I have the survey. I have 300 pages of documentation in 2 binders on a shelf in my office. And I have the knowledge that when it mattered, I did everything right.